Hello and welcome back to yet another session at Lalan's IAS. I am Hiran Sadhya, and so let's begin. This case that we in front of us, Suprio versus Union of India. Some of you might be taken a bit aback that what case is this and how is it in the news? This is the official name of the case. In common media parlance, it is known as the same-sex marriage case. So now everybody must be finding it familiar. But as a serious student of civil services, we should not only go by what is happening, we should also know what is the real subject matter of the things. You might be asked in an interview, what is your opinion on Supriya versus Union of India case? And if you stumble at that point, then it will not be a good thing for you. So this is the case that we will deal in a very exhaustive manner. And what are the issues that we will discuss? The context, what is the case, what was the contention of the petitioners, what was the position of the government. Then we will look into the verdict, the conclusions that has been made, and see in these sensitive matters what one Supreme Court judge has said that such matters are polycentric. Why does he term it polycentric? Because such issues not only has a legal dimension to it, it also has social dimensions, it has political dimensions to it. So what he has attempted, or he has brought to public notice, is that such issues which has multiple centers should be dealt in a very restrained manner by the courts. It is more relevant for other organs of the government. That means there are three basic organs of the government: judiciary, executive, and legislature. So for matters of such wide interpretation of wide centers or multiple centers, it is better to arrive at decision based on taking the broad public opinion into the book. So he has actually refrained from courts making, or refrained he has actually asked for restraint on the part of court while making taking of such decisions. But what I want to make what I want to focus on is that this is a matter which is quite complex, and generally speaking, our interpretation in such matter is very, you can say, binary. We have a binary idea of such things. What do I mean when I say we have a binary idea? It means that whenever such an issue comes up, we either think in terms of yes, it is good, or no, it is not good. Or regarding a Supreme Court opinion, we will say yes, Supreme Court has supported it, no, Supreme Court has not supported it. But the answer lies in the details. The answer lies in the nuances. And this fact has been highlighted by the fact that this judgment is not a unanimous judgment. It is a 3-2 majority judgment. Can you name a case where such a case of such significant proportion, which has actually changed the legal landscape of India as well as political landscape of India, but it was also not passed unanimously. It was passed in 7-6 majority. I'm referring to none other than the basic structure case, or the Kesavananda Bharati case. That was also not a unanimous decision. There was huge debate, but it changed the political and legal landscape of the country. So the fact that it is not a unanimous judgment does not take the legitimacy of the case. In fact, many might be wondering, there are newspaper articles going on that since the Chief Justice of Supreme Court has given a minority judgment. Minority judgment means you can say in a different view. He has signed it as a part of the whole bench, because 3-2 has, the ruling has been on 3-2 basis. That is, three have voted in favor of the overall verdict, and he is with the overall verdict in that regard. But he has also passed a minority opinion on this. But the fact lies that what Supreme Court has observed is now a legal position, and things will move on from there. But always you should be very careful in such matters to not think in terms of good or bad or yes or no. It's not like same-sex marriage is uh, illegal now. It's not something like that. What you just understand the things. If you are asked, do you like after the Supreme versus Union of India case, is same-sex marriage illegal? The answer is no. Same-sex marriage is not illegal. It is not recognized by law. There is a vast gray area within that. So it is a very detailed thing. It's a very nuanced understanding you need to develop. That's why we need to study in a both in a conceptual manner. That's why I have brought in the topics of rights versus liberty. Because if you consider something as a right, then your perspective changes in comparison to if you consider it something as a liberty. Liberty is something you can compromise, but rights you will not be able to compromise. We'll deal with those things later. Then the idea of theory of separation of power is given by Montesquieu. That is at the heart of how democratic governments function, because democratic government stands on the three pillars of judiciary, executive, and legislature, and it is on the pretext, or it is on the understanding that all the three organs will function in a very coordinated manner without transgressing on each other's domain. So that is an essential founding principle of democratic government, and that has been emphasized in the judgment. So you might be asked question on theory of separation of power. So having said that, now coming to the subject matter of the case, what happened is that there was this petition by petitioners led by one Supriyo. So that group filed a petition that uh, we have a special marriage act. Our marriages, or for that matter, in India, marriage is basically a civil union. It is a contract. Marriage is a contract recognized by law. But we have personal laws like Hindu Marriage Act, Islamic Marriage Act, Sikh Marriage Act. So personal laws govern the domain of marriage. But if any civil union does not come under the personal purview of any personal law, there is also the scope of Special Marriage Act. So what does the Special Marriage Act say? Special Marriage Act says that if a person cannot be accommodated, if a couple cannot be accommodated under any other personal laws, then they can come together, because the individual choice of the couple is given primacy under Indian law. The social opinion, legal or cultural opinion, or religious opinion is not given uh, that high a pedestal compared to the individual choice. We will come into those aspects while we study the various Supreme Court cases and the conclusions that can be drawn from it. We have to have a clear understanding of the legal positions of important complex issues. So all those things we will come as we deal this topic. This topic will be a bit long, but it is important for you to have a correct understanding on things. So, Special Marriage Act, the petitioner said that this Special Marriage Act has the what is the current terminologies used? Like it recognizes a couple when a husband and a wife. There should be a husband and a wife. That means there should be a male and a female. But the contention of the petitioners is that this act should be gender neutral. To form a civil union, you need not necessarily require a gender neutral a couple to be of the opposite gender, or in a way, Special Marriage Act or other personal laws only recognizes heterosexual marriages. So this is a position of Special Marriage Act. Now, the contention of the petitioners was that to make it gender neutral. Now, what did the Supreme Court say? The Supreme Court, in its very uh, wisdom, it expressed that, and remember, it was a 5-judge bench, as I pointed out. Now, it was a 3-2 verdict. So, 5-judge bench declined to legalize, or in a way, it declined to uh, accept that Special Marriage Act is gender neutral. Why? Declined to legalize same-sex marriage, not because it is opposed to it. I am very sure at personal level, these people will not have any issues if two persons are coming together regardless of their sex. It is their personal choice. But to arrive at such policy level, this is a policy level decision. Like, what should be the composition of family structure in a society? Or the Supreme Court has rightfully said that such matters of public policy or such matters of um, social issues should be best dealt by the parliament. So it should be, it's not saying that it de-recognizes them, but it says that such decisions are to be taken by the parliament. You can say there are people who are arguing that Supreme Court has just passed the buck. But we will say that no, Supreme Court has not passed the buck to the parliament, but it has actually uh, recognized the principle of theory of separation of power. Under theory of separation of power, such matters which are, you can say, policy level issues, social issues, they are best done through legislation by parliament. And in this regard, Chief Justice Chandrachud said that intervening in such matter will be interpreted as judicial legislation, or what we say as judicial activism or judicial overreach. Such things are not permitted. There are institutional limitation on the judiciary. Institutional limitation. Why there is institutional limitation? Because of the theory of separation of power. So, because theory of separation of power limits the position of judiciary in this regard. Now, so this is the position of the Supreme Court. Now, what have we learned till now? We learned that what was the position of the petitioners? They wanted to make the Special Marriage Act gender neutral. But what did the Supreme Court say? Supreme Court said that such things can only be done by the parliament. So we are not in a position of giving constitutional recognition to same-sex marriage. Such things should come from the parliament. And it is rightly, it's a very correct observation, because public opinion or public pressure or public propaganda is the way through which such matters should come in the legislative domain. Because see how things work in a democracy. When how are politicians made to do certain changes in the society? When there is pressure from the society, when politicians feel that if they don't do that, then they will either have to lose votes or they will have to other parties will gain votes. So that will be the incentive for politicians to act. That is the practical way in which politicians function. So if something is a public issue, that becomes a drive, or that becomes an incentive for them to act. So the correct way would be to create a social movement or social activism through which public pressure can be put on parliament to create such a legislation. Basically, what Supreme Court says that to decide whether the time is right or not, it is not for the judiciary to do it, it is for the society to do it through the parliament. Okay, but again, it's a matter of debate, because if we refer to old Supreme Court cases, like not very old, like 2014, we had the Nalsa judgment. We will look into those. Then 2017, we had the Puttaswamy judgment. 2018, we have the Navtej Singh Johar judgment. All those things were quite revolutionary. Nalsa, we know it recognized transgender rights. Puttaswamy recognized right to privacy as a uh, fundamental right. Then Napte Singh Johar decriminalized homosexuality under 377. So all those things, although there is social acceptance to it, you cannot say that there was a wide public support of all those things, but through judicial interventions, those things came. So it's a very delicate balance, but yeah, judiciary is criticized for such steps, although these are very progressive steps, but ideally in a society where people are enlightened, people have awareness of their rights, people are concerned, have sympathy, or have empathy for the marginalized section among them. Such legislation could come, or such ideas could come through legislation, through parliament. That is the basic idea of democracy. Otherwise, it will monarchy would suffice. But why do we have democracy? We have democracy because we believe that ideas will come from the people. People will generate ideas, and those ideas will be implemented through their functionaries or through their representatives. So that very principle has been highlighted again in this Supreme versus Union of India case. So having said that, now let us go into certain important conclusions or verdict, or what what uh, what deductions we can draw. The conclusions that we can draw from this. The first fact that Supreme Court has said that all all the judges accepted that time to end discrimination against LGBTQIA plus means it is all the sexually marginalized or marginalized people because of their sexual orientation. All everybody comes into this. So for we have to end discrimination. There is no two ways about it. That they have that is the ground rule they have set, and that has been set in Nalsa judgment only, because in Nalsa judgment 2014 Supreme Court clearly said that queerness or any sort of atypical sexual orientation. There is this typical sexual orientation is heterosexual. Anything other than that is atypical, but atypical does not mean unnatural. That is what Nalsa judgment said. So queerness or any atypical sexual orientation is a natural thing, so it should be respected. That is the ground rule. So basic fact is that there should not be discrimination. There should not be uh, chastising of them. There should not be persecution. There should not be uh, violence from, or you can say, state should not act in a discriminatory manner. There is certain, we have reports of police sections against transgenders, treating them in not a very dignified manner. Those things should end, and social responses will also have to change. But the basic ground rule has to be set. First ground rule is that any person, regardless of their sexual orientation, should not be discriminated against. First thing. But second thing, very important. This we will deal while dealing with other fundamental, other Supreme Court cases. Supreme Court clearly said that there is no fundamental right to marry. It might come as a surprise to many, but generally we have this tendency while discussing Article 21 that we can club anything. In fact, in this Laxmikan, there is right to sleep is also part of Article 21. But again, someday Supreme Court might interpret it in a way that right to sleep is no longer a fundamental right. But now it is clearly established that after this judgment that there is no fundamental right to marry. You do not have a fundamental right. You cannot force anybody that, "Oh, you are not letting me marry, that means we will go to court." No. Then what is the fundamental right? We will come to that. That we will come in the cases related to Hadya. Hadya, you might remember Hadya case or Shafin Jahan case. That same case gave the right not to marry, but right to choose a partner. Right to choose a partner is a fundamental right, because that is that uh, that touches Article 19 and 21. But right to marry is, both are different. Right to marry and right to choose a partner. Those cover different aspects of uh, human life. Okay. So these are the two most fundamental things that came out of this judgment. And although, as I pointed out, that the judges, they failed to reach a consensus on giving these couples the status of legally recognized civil union, but at the same time it says that it did not create a roadblock on such a statement or such a position. It said that such a position can only be arrived by the parliament. So Supreme Court does not say that same-sex marriage is illegal. Put it in your mind that Supreme Court did not say same-sex marriage is illegal. Supreme Court said that such a thing can only be done by the legislature. So that is the position of the Supreme Court. And see, when you recognize, it is not merely you are recognizing the civil union. You are certain material benefits flow out of being recognized as a civil union. Say for adoption, say health nominee, you can be a nominee for health insurance, your property related issues. So all those material benefits, certain material benefits flow from being a civil union. So all those things also come with it. So it can actually, if it materializes, then it can give them full membership of the society like any other heterosexual couple. That is the basic idea, and we should actually move towards it. If you ask me personally, then I fully support the idea that it is a personal choice. If somebody wants to be with somebody else, then we should recognize that relationship and give them all the benefits that are given to other couples of opposite gender. So that is personal view, but for it to become a national view, it has to come through the parliament. That is the basic idea of what the Supreme Court has said. So all these things are a natural progression. In fact, the decade of 2010 has been quite revolutionary for the Supreme Court. You might be familiar, there is this term constitutional morality. It was used by Supreme Court for umpteen number of times in this decade. It's a very significant principle that has been drawn in various Supreme Court judgments. In fact, it was used earlier also, but not to that frequency that has been used in this decade. So what does it highlight? It highlights the fact that the foundational principles or moral values that are behind the ideas of our constitution, the idea of equality, the idea that we should treat everybody with dignity, those are the basis why we recognize, say, right to privacy. So all these things is a natural progression which creates a society which creates a society that is equal for all, regardless of your personal choices. That is the basic idea. You have a personal sphere, there you believe in something, there you believe in some ideas. If that is not to the detriment of the larger society, then you can go on practicing those beliefs or practicing those ideas, and you can be given all the support for that. But that should not be at the cost of larger society. But in this case, do you know what is the government's position? Government's position is not directly saying that we oppose same-sex marriage or something like that. Government's position is very clear. It says that personal laws are delicately balanced. It means that personal laws, if you want, personal laws dealing with marriage are very, you can say, very touchy. It is not something you can like poke and change like anything. You cannot amend it in a jiffy. It will create social impact. It can potentially create uh, um, turbulence in the society. So what it says is that it requires time to change such significant issues, and on top of that, it is apprehensive of its impact that might have on the family structure. So you can say that government's view is conservative. Government's view is conservative. Government do not want to create any social upheaval because s- granting such a right will naturally create a social upheaval. It will create changes in society. There will be more social uh, openness towards these things, and it will actually change the existing order. And now, any government of the day is always fearful of any change because of their political compulsions. All these things are there, but regardless of the fact of that fact, change is something you cannot stop. These things will come. Eventually, it will come. So that is the idea that Supreme Court also believe in, that when the time is right, society will assert its position and the legislature will have to implement it. So that is the basic idea that we can draw from it. And remember, court in its previous judgments also, it has said very clearly and categorically that law should prohibit discrimination on the basis of sexual orientation. Law should actually be such that it prohibits discrimination on the basis of whatever sexual orientation that you might have, so that it gives you full effect of being in a civil or a social union, even if you are in a weird relationship. So in a way, it is saying that law should be such that you can live your life fully regardless of your sexual orientation. That is the position of the court that has been uh, expressed in previous cases also. Now, let us look into important Supreme Court cases in this regard. There we will analyze the aspect of rights versus liberty also. Important Supreme Court cases. So first case we will deal with is the 2014 case, that is the NALSA, National Legal Service Authority versus Union of India case. So this is also known as the transgender case. This is in media parlance, you will not generally hear the name of the full case, but generally you will know the main theme of the case. That is how public attention is caught. So Blue case, if you give, then public will not be attracted. But same-sex marriage case, everybody will be familiar. So 2014 case, and all these cases are related to LGBTQ community in one way or the other. So that is why I have tried to assemble all these things at one place. So NALSA, what is the, you might be directly asked, you must have clear idea if you are asked, what is the basic conclusion that you can draw from NALSA? It is that the court upheld the right of transgender person. Remember, transgender is one of the many queer communities. There are lesbian, there are gay, there are bisexual, then transgender. Transgender is one. So we have a law for transgender only. We do not have a law for that covers all type of atypical sexual orientations. So transgender persons, the court upheld the right of transgender persons to decide their gender. Remember now, while filling up any government forms, there is this column for transgender, this third gender, male, female. This is a direct outcome of the NALSA case. So here, court upheld this right, and then it directed the center and state governments to grant legal recognition to their identity. Identity means how they identify themselves. Do they identify as a male, or do they identify as a female, or for that matter, or the third gender? Hmm. So this is judicial activism in a good way, good side. It has brought positive change in society. It's a very, it is kind of a egg and chicken question. Uh, Egg and chicken dilemma. I hope you know that what came first, the egg or the chicken. So it is something like that only. Like positive judicial intervention brings changes in society. At the same time, it is believed that positive intervention should come from the society itself. It should not come from the top. So that is a debatable issue. Sometimes good things naturally come from the bottom, how it should come, but sometimes because of intervention from the top, it comes and it gets general acceptance. Now we accept this fact, but before 2014, nobody was thinking on those lines. Then the second important case in this regard is the case Puttaswamy versus Union of India. This happened in 2017. So it is also known as the right to privacy case. So again, this was a 9-judge bench. Remember, any Supreme Court bench having more than five is a constitutional bench. Supreme Court deals with appellate matter. Supreme Court deals with original matters. Supreme Court deals with constitutional matters. So while dealing with important interpretations of the Constitution, remember, Supreme Court is the guardian of the Constitution. So in that capacity, while it sits, then its bench or its board that it constitutes, that should have 5 or more judges. So the highest bench that we have ever had is the Keshav Nanda Bharati case, where we had 13 judges. Case Puttaswamy is another big judge bench. It's a 9-judge bench. So it gives more legitimacy to it. So supposing superior judgment has to be overturned, then it has to be overturned by a judge, by a bench of more than 5. That is maybe 7 judge or 9 judge. So case Puttaswamy was a 9-judge bench. Supreme Court, and it recognized what was the main conclusion we can draw. It recognized the right to privacy as a fundamental right under Article 21 of the Constitution. So that is the basic conclusion. And how does it impact LGBTQ community or people with atypical sexual orientation? It is because, again, privacy is important for them, and privacy and dignity makes their identity, their orientation, sexual orientation, although it is not typical in the narrowest term possible, because we do not actually have any census data, any proper data to extrapolate those things, but maybe more people might not be accepting it, but such atypical sexual orientation are not that uncommon. People are more expressive nowadays on those things. It's not, at least we can draw this conclusion that it is not unnatural. So sexual orientation is an important part of your identity. If you're not able to express yourself fully, then your identity becomes a problem. So that can only be possible if your privacy is protected. So equal protection demands protection of the identity also. So that is how your discrimination will be stopped, or you can not be discriminated against. Remember, in this regard, I will draw it to you another Supreme Court 2-judge bench case, Kaushal case. It is also known as the Kaushal case. It happened in the year 2014 only. So what it was, it came to the conclusion that 377 is constitutional. Article 377 actually relates to unnatural sex, or that was later placed in Johar. 377 was considered null and void to the extent that it criminalized homosexuality. But Kaushal case upheld 377. And what was its argument? It said that the so-called rights of the atypical sexual genders, or the people of LGBTQ plus I community, is more, you can say, Western driven, something like that. So In a way, you can say that in the Koshal case, it reduced the rights to the scope of liberty. That means when we are saying somebody has a liberty, it means it is not a very essential thing. It can be curtailed it to, and it might not affect it that much. Say you have the liberty to go out of a room, but that liberty can be curtailed to an extent. But if you have a right to go out of a room and then it is curtailed, then it impacts your overall personality, it impacts your development. So right is more deep rooted, and right is something which is recognized both by society and state. So right is at a higher pedestal than liberty. So when we say that somebody has a liberty, that is somewhat you're putting it here. But when you say somebody has a right to do something, that is, you can say it has more social acceptance, and that's without having that right, the person cannot grow, or cannot develop. So, but liberty is something you are denigrating it, or you are lowering the extent of requirement of that. So if you say that the claims of LGBTQ community is merely a liberty, that means you are actually putting it at a lower pedestal, that okay, that is something that can be compromised. But when you say that it is a right, that means it cannot be compromised. It is given by the society, it is accepted by the state, and that is something which cannot be undermined at any under any condition. So social judgment actually reduced the claims of the LGBT community to the nature of liberty, and that is how 377 was considered okay. But later that idea was challenged in Navtej Singh Johar, and that judgment was overturned. So in this regard, that is why it is important, and it is important for any marginalized community, be it women, be it children, be it laborers, be it people from poor socioeconomic strata, that whatever claims they make, the claims can be interpreted either as a liberty or freedom, or it can be interpreted as a right. Right now in India, we are in our syllabus also it is there that we have this rights-based approach to social welfare. What does it mean? Like we are giving free food to people, or we are giving jobs under MCNRC. Many might consider it uh, as a liberty, or as a freebie, or you can say uh, as a as a boon from the government. But no, it is not something like that. Being a citizen of a country entitles you to certain rights, that you should not die of hunger, you should not die of being unemployed, or you should not suffer such adversities of life. So that is your right as a member of a community that calls itself a state. So to exercise those rights, you have this phenomenon. We had this very recent debate in Assam regarding how the position of teachers are. It created quite a turmoil. Like, do can teachers be considered as beneficiaries? Beneficiaries. So this you might face in the interview. Then you have to again ask, then are the government benefactors, or are the government somebody? What is the position of the government? What is the rightful position of the government in a society? Is it merely to pass on certain benefits, or give some doles? No, it doesn't give it out of pocket. It mobilizes the resources, and then again it distributes it. Mobilizing and distribution of resources is the main work of the government. So that it is a constitutional position that it has been given. Now, if that is seen as distribution of resources out of its own hand, that is a wrong interpretation of the government. That way, you cannot say that the teachers are beneficiaries. Although they take salary, there is an obligation of them towards their employer. But teacher has a larger role to play in society. Without their social impact in society is quite large. Quite, you cannot actually quantify it in terms of numbers, in terms of salary. So that way, just considering them as a mere beneficiary of certain roles of government is actually a high-handed approach of the government towards this regard. So you cannot consider teacher as merely beneficiary. although they are under obligation to do certain duties because they are taking money or they are under employment of the state, but that does not make the state as the uh, that does not take away the responsibility of the state, or that does not take away the fact that state also has a role to play under the constitutional scheme of things. Okay, so that is how you should look at it. Teachers are not merely beneficiaries. They have obligations. They have obligations to the state, but they are not merely beneficiaries. They have a role to perform. State also has a role to perform. So you have to look it in that aspect. Whose role is what under the constitution. So that is how you can interpret those things. So there also this idea of liberty and rights come, and be mindful of this fact that liberty, or when we say somebody has a right, that puts it at a higher pedestal. And in Swami, when you recognize the right, privacy as a right, not as a liberty. Privacy is something we might consider it as a liberty, like, we might not be willing to share what we are looking at. That can be considered as a liberty as well as a right. When we are considering it as a right, it makes it quite sacrosanct. It becomes part of our identity. If we lose it, then we lose our identity. So such things are important for protection or against discrimination of LGBTQ community, and that fact can be interpreted through the Facebook Swami judgment. Now, coming to the third case, Safin Jahan versus Union of India case. This is also known as the Hadya case. What is the Hadya case? Again, Hadya case, many will interpret it as right to marry, but no. What happened was that in 2018, Kerala High Court judgment annulled the marriage of a girl who converted to Islam and married a man of her choice. But Supreme Court, it recognized the right to choose one's partner as a fundamental right. As a, you can say, corollary to Article 19 and 21. Like, if you are giving a person rights under Article 19, that is right to freedom of speech and expression, and you are giving a person Article 21, that is right to life of dignity, that can only be realized if you are also giving that person the right to choose your partner, regardless of the partnership being a marriage or not. If you are not recognizing that individual capacity of that person, then you are not giving him Article 21 and 19 in the full extent. So what Safin Jahan case said is that right to marry is not a fundamental right, but it says that right to choose a partner is. Right to choose one's partner is your sole prerogative. This comes under fundamental right, liberty and dignity. I hope you're able to understand these things. If you don't, then you can contact me. You have my number. For any doubt, you can message me, call me. So Supreme Court emphasized this fact that it comes under the core zone of privacy, where it is inviolable. It is absolute right of the individual to choose this partner. You are not limited by what the faith say or what the society say. Okay, it recognized that. And flowing from this only, another very important case is the Shakti Bahini case. These cases are very important from mains perspective, actually, means because while dealing with any questions relating to these aspects, if you are actually highlighting these cases, then that is really a good thing. You should actually. And it's not like you have to remember hundreds of cases. If you properly synchronize or if you assemble these things properly, there will hardly be 20 to 30 cases that you need in your UPSC preparation. 20 to 30 cases, if you can recall at the right time, at the right place, then that will fetch you really well, help you really well. So 20, 30 cases is nothing. Na? You remember many things in life. So this is something. So Shakti Bahini versus Union of India case, again, this is 2018 case. Well, Supreme Court said that it was basically to prevent honor killings. Prevent honor killings at the behest of Khap Panchayats. I'm sure you know all these things. These are in news. Uh, so it protects the person who marry without the approval of the panchayats. So again, their court recognized the right to choose a life partner as a fundamental right. It is not because right, again, I will emphasize, re-emphasize this point because I am very sure some people will interpret it differently, like, okay, because marriage is a fundamental right, that is why Supreme Court is protecting. No, Supreme Court is not protecting your right to marry. Supreme Court is protecting your right to choose a life partner. That is a fundamental right. So even if you are not married, you are having a choice and you are staying with them, that is also protected under. So when basically when two adults consensually choose each other as life partners, it is a manifestation of their choice, which is recognized under Articles 19 and 21. Supreme Court writes this thing in a very succinct and beautiful language, which is actually good to remember and very good to read also. So do read what Supreme Court conclusions come in newspapers. Those are very good conclusions. In this recent same-sex marriage case also, CJI Chandrachud made certain observations, uh, really succinct and really beautiful. So you don't try to memorize this thing, just read 2 or 3 times. Then these things will be there stored in your memory and it will come in the right time, it will come. So here Supreme Court said that when two adults consensually choose each other as life partners, comma, it is a manifestation of their choice, which is recognized under Articles 19 and 21 of the Constitution. So that is what Supreme Court has said in the Sakti Bahini case, that um, once the Constitution recognizes it, then there is uh, you need to protect it. So you cannot actually uh, make it subservient to group thinking or honor such ideas. So it puts an obligation on the state to protect those couples. Okay, Sakti Bahini case. Then fifthly, very important case, Navtej Singh Johar case. It actually overturned the Koshal case, Koshal judgment. So it came again in the year 2018. It came. 2018 was a very landmark year. In that year, UPSC, many predictable questions came, like same-sex marriage. Sorry, this Navtej Singh Johar, right to privacy. Then uh, there was this question regarding the digital data protection because B.N. Krishnaswamy's uh, report came in that area. So these things, which are really big issues, they generally come in exam. And those are the things that comes to the examiner's mind. Those are the things you should always look forward in a proper manner. So in Navtej Singh Johar, Supreme Court actually overturned this Koshal judgment, where again this was a 5 judgments. It struck down IPC section 377 to the extent it didn't strike down fully. It said that to the extent that it criminalizes homosexuality. You read yesterday's newspaper, that is 28th October. There was this parliamentary committee report on uh, the criminal law amendments that are supposed to be made, IPC amendments. So there it is saying that 377 should be kept. Why? Not to criminalize homosexuality, but to prevent, say, child abuse, huh, or such acts against children, or uh, unnatural sex can be against other creatures also, no? Animals. So those aspects also need to be protected. So 377 is still there in our statute, but to the extent that it criminalized homosexuality, that part has been now out of it. You cannot go to police station, and file a case under 377 saying that a couple is homosexual. No, that part has been struck down by Navtesh Singh Johar case. So what is the main idea that we can draw is that essentially LGBTQ community are equal citizens, and there cannot be a legal discrimination against anybody based on their sexual orientation or gender. That is, I mean, we are talking about the idea of equality, that regardless of your sexual orientation, there cannot be discrimination against you, either legally or for that matter, socially or politically. This is an accepted fact. On the day we are discussing these things, like by 2023, India believes that discrimination against somebody with sexual orientation should not be there. But 2023, India is not in a position to recognize same-sex marriage yet. Those things will come at a later day when society maybe matures more or demands more. So that is the basic conclusion that we can draw from this whole topic.